You're thinking about bringing a lawsuit against your doctor for causing you significant harm and injury. But before you do that, you've heard that there's a lot of things that go on during the first court conference that you're not present for. Let me share with you one thing that you should be aware of, and this way it'll give you a better understanding of what happens next. You want to learn what I'm talking about? Come join me for a moment as I share with you some great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. So now, after your lawsuit gets started, after we have a medical expert confirm that you have a valid basis for a case, now, a number of months later, the attorneys get called into court to have what's known as a preliminary conference. That's really a scheduling conference. And now it's a schedule to make sure that certain things are done over a course of time. The judge wants to make sure that certain documents are exchanged and that everybody knows where they're supposed to be, when they're supposed to do it, and this way everybody signs off on this. And this becomes an order that the attorneys must follow. One of the things the defense attorneys like to do during this preliminary conference is to ask us for years and years worth of your past medical records. They're not happy to say, okay, just give us a year or two worth of the past medical records. Instead, they say, give us years and years. Give us 5 years, 10 years, 15 years, 20 years worth of medical records. And you know what we say to that? No, sorry. The most you're going to get, willingly, voluntarily, is 3 years worth of our client's past medical records. Now, why is that? Because that gives them an insight into what went on for a reasonable period of time before the incident happened with the doctor that you're bringing a lawsuit against. So the defense has an opportunity to go back in time to before you started treating with their particular doctor. What if the defense is able to look at those 3 years of past medical records and realize, wait a second, you've been under the care of doctors for this particular problem for years and years. Can they ask the court for more years worth of your medical records? The answer is, yes, they can. And if they can show that there is a connection between the ongoing care and treatment that you received years earlier, beyond the 3 years in the past, in all likelihood, the court is going to allow them to get many more years worth of your medical records in the past, provided they can show that there is that connection. Now, they don't have to show with absolute certainty that there's a connection. They only have to show that there is a viable possibility that these are connected. Simply because they are asking and are able to show that there's some connection, the judge may allow them. Why? Because when they get those records, if they can't show that there's a connection, they won't be able to use those records later on. However, here's the twist. There might be something in those records going back 5, 10, 20 years that might be damaging. That might be damaging to you and to your case. You might have said something to one of your doctors at some point in time that contradicts something you are saying now in your particular case. And I guarantee you the defense is going to comb through every single page of every one of your medical records to find that one contradiction, the two contradictions, something where you complained about something or where you had no complaints. And now you're saying that their doctor caused all of these problems or something totally different. So why do I share this great information? I share it with you just to give you an insight and an understanding into what goes on in these medical malpractice cases here in New York. You know, I understand you're watching this video because you have questions or concerns about your own matter. Well, if your matter did happen here in New York and you're thinking about bringing a lawsuit, but haven't done so yet because you still have questions that need to be answered, then I invite you to pick up the phone and call me. Why? Because I answer questions like yours every single day and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.